Over there.
Over there.
Oh, hi there.
I miss you, Leslie. Should I welcome to join?
Bobby. Bobby was here.
It'll be okay. Yeah, okay. All right.
There she is.
This is the regular meeting of the Ojai Planning Commission for May 17th, 2017. Members of the public wishing to address the Planning Commission on items appearing on the agenda are requested to complete a speaker's card and file it with the secretary prior to the start of the meeting. Cards are available in the lobby. Speakers should state their name and address for the record, and please limit your comments to 3 minutes or less. Comments must be directed to the commission, not the audience. While the Planning Commission is in session, all in attendance are expected to maintain order and decorum and to obey the orders of the chair. Could we have roll call, please?
Chair Merck,
Here.
Vice Chair Quillisi,
Here.
Commissioner Zabella,
Here.
Corbin,
Here.
Jagiello,
Here.
Nolan,
Here.
Powers.
Here.
Thank you. Commissioner Nolan, could you lead us in the Pledge of Allegiance?
Yes, please rise. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Public communications is the time set aside during the Planning Commission meeting for members of the public to address the Planning Commission on items of city business other than scheduled agenda items. Matters raised at this time may be briefly discussed by the Commission and will generally be referred to staff and/or placed on a subsequent agenda. Under state law, other than for emergency items, no action can be taken at this meeting. So anyone wants to speak on an item not on the agenda? All right, we will move along to consent items. All matters listed on the consent calendar are to be considered routine by the governing bodies and will be enacted by one motion in the form listed. There will be no discussion of these items unless before the governing body votes on the motion to adopt, specific items are removed from the consent calendar for separate motions. The first item is minutes of the regular meeting of the Planning Commission for April 5th, 2017. Could I have a motion on this?
I'll move approval as amended. I gave a correction to Sherry.
Thank you.
I will second the
All
motion.
right. Could we have a roll call, please?
Zabella,
Yes.
Corbin. I believe you're abstaining from this? You going to abstain? I think you were absent this meeting.
Yes, I will abstain,
Thank you. Jagiello?
Yes.
Quillisi?
Yes.
Merck,
Yes.
Nolan?
Yes.
Powers.
Yes.
Thank you.
Thank you. Next is the minutes of the regular meeting of the Planning Commission for April 19th, 2017. And could we have a motion on that, please?
I'll make a motion to approve the minutes on
Thank
April
you.
19th.
Is there a second?
I'll second that.
Thank you. Any discussion? Could we have a roll call, please?
Zabella,
Yes.
Corbin?
Yes.
Jagiello?
Yes.
Quillisi?
Yes.
Merck,
Yes.
Nolan?
Yes.
Powers.
Yes.
And
Thank
you're
you.
abstaining because you weren't here to lead that meeting.
I abstain.
Thank you.
Thank you. Next is disclosure of site visits and ex parte contacts. Commissioner Zabala, could we start with you?
Sure, I've visited both sites and have had no ex parte contacts.
Both sites?
I visited both sites and had no ex parte contacts.
I visited the sites and had no ex parte contact.
I visited both sites, took a lot of effort to see the site in item 3, but had no ex parte contacts.
All right. Kathleen?
I too visited both sites and had no ex parte contacts.
I visited both sites, had no ex parte contact.
Okay. I'm very familiar with the item, the parcel in item 3, as I've been to many parties and festivals there over the years, but I understand it's a different owner now, and I haven't had any ex parte contacts. I also attended the review for item 4 with the Committee to Approve Public Art last week. So I'm probably more familiar with that than most people. And that is it for that. So we're going to move on to our public hearing items. Item 3 is Design Review Permit DRP 1611 for an addition to an existing two-story residence at 815 Libby Avenue. Assessor's parcel number is 02000800210. The general plan designation of the site is low-density residential, LR. The zoning classification is single-family low-density, RO1. A categorical exemption has been prepared pursuant to the California Environmental Quality Act. Property owners are Kylie Schuler and Douglas Hodge, and we have a different person representing the architect tonight. Yeah, thank you. Could we hear from staff on this?
Yes, thank you, and good evening, Mr. Chairman, members of the commission. This design review permit concerns a proposal to remodel an existing two-story single-family home and add an addition to the structure, which would be located over the existing garage component of the structure. The addition would be approximately 476 square feet. The property is almost 2 acres in size, 1.85 acres. The existing residence is 8,704 square feet in size, so the addition would put it over 5,000 square feet. The basic proposal is to provide a facelift to the existing Tudor style of the architectural style of the structure. The new style would be more of a country chateau, as indicated by the applicant. They would be replacing the roof element in addition to replacing the roof materials in addition to the addition that is being constructed. There was an issue originally with the original application concerning the height limit. The height limit in this zone is 25 feet. The commission is previously, or the existing structure is not conforming. It has a 35-foot height associated with it. We worked with the applicant to make the addition conform to a 30-foot height limit, which is which includes a 5-foot additive that the Planning Commission can grant through the development review permit. And staff is recommending that you do so. We're passing around colored elevations of the before and after of the home, as well as a material board. Staff recommends approval of the application. Commissioner Vice Chair Quilisi did distribute and we distribute on his behalf a number of questions that were asked concerning the items on your agenda this evening. As a result, we do have a couple of modifications to the proposed resolution. We do recommend striking condition number 2, the line that says no additional dwelling units are allowed on the property. That would be enabled by the city code and the state laws that applies to additional accessory dwelling units if someone should choose to pursue that in the future. With respect to condition number 9, will serve letter, since this is an addition, that will not be required as well. So condition number 9 can be deleted. Condition number 14 actually relates to condition number 4. That's the archaeological standard condition. And so that could be reordered to be new condition number 5. And it does apply in as much as there may be structural adjustments to the footings, the foundation of the structure related to new addition, so there may be some disturbance, ground disturbance, so those conditions should apply. Okay, city attorneys are recommending that condition number 14 and 15 be reordered to follow condition number 4, so they'd be new number 5 and 6, and the rest of the conditions would be adjusted accordingly. And with respect to condition number 21, Vice Chairman recommended that the words after completion of construction be added, and we agree with that suggestion and recommendation. The condition number 23 concerns, the question was whether or not the county fire department would have to review the plans. They are the plan check reviewing agency for all new structures, and so that will be required. And with respect to condition number 25, as it applies to spark arresters for chimneys, I believe they will be modifying the fireplaces associated with the structure. And so spark arresters will be required, or may be required by the county fire department, but that would be determined at the time of plan check.
As a retrofit, even though it's part of the existing building?
Could be if they're being altered, yes, sir.
Okay?
And again, with those changes, staff recommends approval of the development review permit.
Thank you, Mr.
The applicant
Winiger.
is represented this evening.
Yeah. Do we have any questions for staff? Right.
Could you reiterate for me the first point you mentioned about 80 accessory dwelling unit or extra units?
Yes, condition number 2.
Yes.
It says the second line, no additional dwelling units are allowed on the property, on the project or the property. We would just recommend striking that language, that the regulation of additional units will be covered by the city's zoning ordinance and state
Parts
law.
of the code, yeah.
Got it. Thank you.
Okay. Any other questions? Leslie?
I have a question about the extra 5 feet that are in the mix here from the standard.
Yes.
I thought that was for sort of architectural elements, not the roof line.
That generally is the case, because of the existing structure and the way it's constructed. We felt that was consistent with the intent of the ordinance, but it can be interpreted, strictly speaking, to apply to decorative elements. But I think there is latitude for the commission to make that determination. Right. So there's a note on page 3 of 4. The note underneath the table indicates architectural features and roof lines, so it does include roof lines in residential zones in excess of 25 feet, but no more than 30 feet may be approved.
Gotcha.
But this requires explicit permission from the Planning Commission, unlike the setback provisions of 10-2.1303F, which say by right, if you're staying within the setback envelope of the existing building, then you can go ahead and build what you want. Is that correct, Mr. Summers?
Yes, provided that you meet the standards of the section you cited.
Sure, sure.
So, Mr. Winiger, do we have to make that an explicit part of our motion to approve this project?
It should be a part of your resolution
Part of the
findings.
resolution, yeah.
Okay.
If it's not, it should be. Okay. Yes, it is part of your resolution.
It is.
It is paragraph A on attachment A, page 1 of 8.
Okay, thank you. Any other questions for staff?
I did have one other question, and I thank you very much for the timely and concise and complete responses to my questions, sir. However, I did get this response back from the city building official. Where is it now? Saying regarding the fire department plan checks, oh, here it is. CAA has not been contracted with the city to provide fire plan review and inspections at this time. Am I to understand that the city building official is certified, but by the city's rulings of whatever sort is not authorized to do fire plan checks?
As I understand the matter, and I haven't spoken with the building official on this question at the moment, so that's the caveat. As I understand the matter, the current city CAA Charles Abbott Associates contract that provides for the building official's contract services does not include the building official serving as a fire approving authority. That option remains within the council. I understand the council will be looking at that contract at their next meeting on Tuesday for a midterm performance review, and I expect that that'll be part of the discussions. I also understand that absent that provision occurring, the Ventura County Fire Protection District is the permitting agency
They would retain that function, sure.
as a result of the city having joined that district some years ago. And I invite further questions or comments on that. You might look to the public comment.
Yes.
Okay.
Would you like to get clarification on that from Mr.?
Yeah.
Mr. Warwick, why don't you come up?
Thank you, Chair. Mark, I wanted to address that question because the reference to the Ventura County Fire Department ordinances, we've not adopted anything above state mandates. So when they say adopting and reviewing and enforcing the Ventura County Fire Department ordinances, that's not exactly correct. We've not adopted anything over and above state code, and that seems to read that they would be enforcing as part of that stipulation over and above state code. And that's not correct.
And that is agreed, not correct, and not at all staff's intention. I'll suggest some language to build that in.
Thank you.
That language could be, this would be added to condition number 23. At the end, the applicant shall comply with fire department standards for fire flow, fire protection, sprinklers, and vehicular access only to the extent these standards apply in the city.
Correct.
Which would build in the allowance between the time, if the council does adopt some or all of what they're after, what the county has asked for between the time today and when this is.
Right, but it doesn't usurp the council authority to make that decision.
Correct.
Or to put over and above state code requirements that council hasn't adopted on the applicant.
Correct.
All right, thank you.
So Mr. Summers' language here to say only to the extent that, et cetera,
Yes,
just means whatever the council does, that's going to be the rule.
right.
But we still need to then do something with the CAA contract to authorize the city building
Well,
official.
That's a separate issue
That's a
that's not on
separate
your
issue.
agenda tonight.
No, it's not on our agenda.
Yeah.
Yeah.
I was just bringing up what code to apply.
Yeah.
And the wording seemed to applying something from the Ventura County Fire Department that we've not yet adopted.
Yeah.
And I want to make sure that was clarified.
And certainly not the intent, so it's
Okay.
a great point. So the language, again, to read for the record, the suggestion is that the final sentence in condition 23 would read, the applicant shall comply with fire department standards for fire flow, fire protection, sprinklers, and vehicular access only to the extent these standards apply in the city of Ojai.
Right.
Which builds in at the moment the straight state standards. And if the council changes the state, adopts something above the state minimum, then it would build that in at that time.
Excellent.
Thank you, Mr.
Excellent.
Warwick. All right, any other questions? All right, could we hear from the applicant, please?
Hello, my name is Pablo Garcia. I'm with the architecture firm of James Armstrong and Associates out of Ventura, and I'm here representing the owners, the representative who couldn't be here, which is Peter Livingston, and our firm as well. So, if you have any questions,
Any questions for the applicant? No?
that's
sir.
basically what I showed up for, make sure that, and wanted to thank also Sherry and all the staff. We went through many iterations of the project, and, everything was very helpful, smooth, and also just to, on behalf of the owners, this is a project that's very dear to them, and they're very vested in. So we're very happy to be on board with, and I think you can all expect a very positive and wonderful project out of this. Yeah.
Thank you very much. I'm glad to hear that things went smoothly with the city. Did you have a question for?
Yes, I did.
Mr. Quilisi had a question.
Just a couple of questions.
Sure.
Thank you. I had to kind of walk around the boundaries of the property to be able to see anything. You've got an 8-foot wall or thereabouts around it. But at the northeast corner of the property, where the wall along Libby Avenue changes to a wire fence of some sort that runs along the north edge of the project, or of the property, I saw a large, well, not large, but I saw a building there. It's white in color, asphalt roof, I think, but it might have been tile. And I'm just wondering, is that a storage facility? Is that a garage? Or is it, it's not a guest house or a?
No, it's there's a pool house and also an equipment building for
Okay.
for all the pool equipment.
Okay,
But it's not a residence of any sort.
okay. Just one last question then. The main gate to the property, which is at the south end, was kind of in the middle of the big brick wall, or has two addresses, 709 and 815 on it.
Correct.
And down at the south end of the wall, a 709 appears again, and there's a residence there. But if you look straight in the driveway, at where it says 709 and 815, there appears to be another building to the left that is downhill a bit from the main house. Is that a guest house? Is that a second residence, or what? I'm just curious.
There's actually two properties that are side by side. They've been owned by the same, they have the same owner. There was kind of a lot tie that ties the two lots together. And I did a little bit of research along with Jay from your planner.
Jay Higgins, our
Jay
planner.
Higgins,
yeah.
yes. With the county on how that whole area was divided up, and there were some parts to the south and to the west that were also, there were some variances on some of those properties as they were sectioned off. Those two lots have been together throughout the development of that property. So that main entrance actually serves the one of the houses from the south property, but it's owned by the same family.
So one family owns the big house that we're addressing tonight, plus the smaller residence that's just south of the driveway.
The driveway,
And
correct.
709 is the third residence.
The third residence.
That's behind the wall.
And it's all three residences are owned by the same family.
Okay, okay, very good. Thank you, sir.
No problem.
Thank you, Mr. Garcia. This is the public hearing. Is there anyone, I have a speaker's card from Mr. Wyrick, but is there anyone else who would like to speak? Mr. Wyrick is waiving his right to speak. Anyone else would like to speak on this item? I'm going to close the public hearing. And is there any discussion, or should we entertain a motion?
I'll make a motion.
Thank you, Chair.
This is a no-brainer.
All right.
I call for a motion to approve design permit DRP 16-11 for a second-level remodel in addition to 815 Libby Avenue.
Thank you. Is there a second?
Should we say with the conditions as stated by staff?
With the findings and
The findings
conditions
and
of
conditions.
approval.
Earlier stated by
What he said. Okay.
staff, yes. what he
And
said.
Bobby, you want to second that? All right, we have a motion and a second. Is there any further discussion? Could we have a roll call, please?
Isabella?
Yes.
Corbin?
Yes.
Jagiello?
Yes.
Quillisi?
Yes.
Merk?
Yes.
Nolan?
Yes.
Powers?
Yes.
Motion passes.
All right. Thank you all. Thank you, Mr. Garcia, for coming all this way. Next item is item 4 on our agenda. Let me just get the wording correct here. Design review permit, DRP 16-13 for the Ojai Valley Museum to install 2 new gates, repaint the sign on the stucco immediately above the crown of the entrance arch, repair damage to the arch and walls, and plant 2 new trees and lavender at Historic Landmark Number 7, St. Thomas Aquinas Chapel, AKA the Ojai Valley Museum at 130 West Ojai Avenue. Could we hear from staff on this, please?
Yes, thank you again, Mr. Chairman. As you indicated, this is a proposal to install 2 gates that provide entry to the courtyard of the Ojai Valley Museum. The museum is, as you indicated, City Landmark Number 7, the former St. Thomas Aquinas Chapel, which has been adapted for use by the Ojai Valley Museum. The proposal concerns not only the gates, but originally also proposed some modifications to the landscaping. That portion of the request has been withdrawn by the museum. So the strictly speaking, the issue before you is the approval of the two gates rather, which will also involve repair of the archway and the walls adjacent to where the gates will be installed, and repainting of the Ojai Valley Museum title on the arch itself. The Because of its landmark status, the approval of the gates is also subject to review by the Historic Preservation Commission. The gates were funded and are at least partially funded by an allocation from the City Council with the intention that they be decorative and artistic in nature. At a joint meeting last week, the committee to approve public art approved the gates and is recommending approval to the Arts Commission, and the Historic Preservation Commission adopted or approved a work permit for the gates as well. The proposal also requires approval by the Planning Commission, so it is before you this evening. With the recommendation of the committee to approve public art and the action of the Historic Preservation Commission, along with the changes I've indicated here, staff is recommending approval of the design review permit. I'd be happy to try and answer any questions that you may have. I believe your packet includes the redesigned gates.
Yeah. Thank you, Mr. Winiger. Do we have any questions for staff? All right.
I had one. I submitted 3 questions, and I very much appreciate your responses to those again, sir. The administrative report, page 2, first bullet, discussing the application, said the gates were for security reasons. Was it your sense in dealing with the applicant that there have been security problems in the courtyard of the museum, and that is their intent to keep the gates closed and keep the public out during the hours that the museum is closed? Or I didn't understand.
Yes, the representative of the museum is here and can probably answer those questions better.
Okay.
But my understanding is there have been issues before. The gates will not, at least initially, have locks on them, but will provide some control to the area involved. And I
Some
believe
visual security.
Correct. And I believe the city attorney also can provide some additional information.
Okay.
Yeah, the added point there is that, as I understand it, the gates are both required by the museum's insurance and serve a further purpose in that when you have gates like that, even though the wall is relatively short and could be hopped by someone who's athletic, the fact that you'd be hopping into a confined, closed space converts that crime from trespass to burglary. Even if the gates aren't locked, they define a space, they define an area that is thus protected under that doctrine of cases. So it converts the crime, it thus converts the police's the focus of the police on the matter. Even if the gates aren't locked, the rule is still the same as your house. If you don't lock your front door, someone comes in, it's a different, burglary by force versus regular burglary, but still, it remains burglary.
Still B&E, yeah.
Exactly, it's breaking and entering, or just the entering of breaking and entering. So there's a further purpose there that's independent of the lock. Certainly, from a physical security perspective, a very tall wall with barbed wire and locks is effective, but that would also be aesthetically terrible. So this is one of the compromises that's built in working with a landmark building. And I'm sure the museum reps who are present could speak to that in greater detail. Thank you.
We did have a long discussion about that at the CAPA meeting where the insurance company apparently is requiring these gates, but they are not going to be locked. So they're going to be beautiful. Anyway.
And just one more.
Sure.
I may have missed you answering my question about condition 13. Where it said, it previously said a final report submitted by the archaeologist and Native Americans prior to issuance of a certificate of occupancy.
Yes, thank you.
How does that apply to gates?
Thank you for reminding me of that question. We can we delete the reference to certificate of occupancy and just replace that with final inspection.
Okay.
And just for the record, a Phase 1 report has been submitted by the museum.
Thank you very much. Any other questions? So this is a public hearing. Can we hear from the museum or?
Good evening. I'm Wendy Barker, Executive Director of the Ojai Valley Museum. So to your question, we have had several incidents of vandalism 2 years ago, before this all started, before I was involved at the museum. So our insurance company has asked that we get gates. That's what started this whole thing. In terms of locking them, the walls around are only 4 feet tall, so it's quite easy to hop. And if we do the Knox box lock, it's a really big thing, and you have to have it within a certain number of feet, the key that the fire, and there's really no place to put it except for like on that wall. So we don't want to touch the wall. So that's where we're at. And the incidences that we did have of vandalism, I think one was somebody mentally unstable, the other one was people who were intoxicated. So the idea is that by having gates, even if they're not physically locked, it's enough of a deterrent.
More of a deterrent, yes.
Yes.
And by the way, I wanted to compliment you on the idea of repairing the brickwork in the gate.
It's scary. When you really look at it, I'm the one that brought that up. I don't think anybody, staff at the museum or at the city had really looked at it in a long time. And we don't want to do it, make it look perfect, but we want to arrest any further decay. And my real concern is water. They're porous bricks. And I mean, there's places where you can stick your fingers in there. It needs addressed.
That's good.
I thought Mr. Luffner's design was interesting. It's completely independent of the surrounding brickwork and everything.
Mm-hmm.
So
Yeah,
it's not going to affect the wall at all, though that you do want to make the changes to the wall before you put the gate in place.
Exactly. But for us, as a historic preservationist, I think it's important, especially on a National Register building, to not impact the original historic fabric, and especially when it's not in good condition and is materials that can deteriorate over time. And, these gates will last decades, maybe, much longer. So they're way stronger than the masonry materials.
Yeah.
The discussion that was in here, it was not clear to me where you intended to hinge the gates. Are you gonna drill holes in the concrete walkway that's behind the arch? And
the concrete in front of both gates, or actually behind them, is I think it's 4 inches wide. The city is going to do that work. Just cut it out and dig deep enough for the.
Put a post to hinge the gate.
It's all together. It's like a U, and they come up, and then the gates just slide on them. So that's a one-piece unit that will be strong enough so that if somebody like a kid or even an adult try to hang on it, it's not going to put them out of whack because
Much
they'll
better,
be
yeah.
together. Yeah, it's a great system that Doug has worked
And
out.
so the gates will be up close to the archway, but not touching it? Just
I think
immediately behind the archway?
Immediately behind.
Yeah.
And they
Okay.
open out that way, so then they'll be left open, most of the time. And the museum's open 6 days a week. And the visitor center, which is next to the Blanche Street, that's open 7 days a week. So, this is really just closed.
So it's really nighttime that you're going to have the
Yes.
gates closed? Yeah.
Exactly.
Okay, great.
Mr. Chairman, there's an illustration on attachment C, page 7 of 48, that shows the way the foundation was. So the gates will be independent. They will not be attached to the wall itself. And then there's another
that
illustration on page 11 of 48 that shows how the gate basically sits within the arch itself.
Yeah, exactly.
Yes.
Thank you. Any other questions for the owner? Anybody? Okay, thank you.
Okay, thank
Thank
you.
you, Wendy. This is a public hearing. Is there anybody else that would like to speak? Don, you want to come up?
Good evening, Dawn Teeting. I'm with the museum, wearing the museum hat right now. I'd just like to address, I was actually at the museum for the last instance of vandalism, which was April 2015. We had 2 prior incidents, one in the front courtyard, one in the back courtyard. We subsequently, prior to that, had installed gates in the back area, in the parking lot area, which are locked when the museum is closed, and that has helped us as a deterrent to any issues in the back. After the event in April 2015, I had the Ventura County Sheriff come out and do a security assessment of the museum grounds, And their number one recommendation was to install gates to deter access. And so this is the first part of the recommendation in terms of increasing our security. We have had some problems with transients on the property in the past, historically. The officer who came out knew what had happened in April and did say that had we had gates, we just happened to be in the line of fire of this gentleman and what happened that evening. Had we had gates, the vandalism probably would not have occurred. We would not have been subject to that. I also was the one who spoke with the insurance company, and yes, the insurance company is, because of the number of incidents of vandalism that we've had, they're looking for an increase in security. The building itself is owned by the city. We are renters, leasers of the building. And this was a recommendation, again, that they're looking for an increase in our security. So we appreciate your support of the project.
Okay.
Thank you.
Thank you, Dawn. Anybody else would like to speak on this project? I'm going to close the public hearing and open it up to Planning Commission discussion. Do we have any discussion, or could I entertain a motion?
I had one more question. I direct it to staff, and maybe the applicant will answer it instead. I walked past the property again today. I've obviously been there a number of times, but I noticed on the Blanche Street gate proposed site that there is already a metal railing that comes down the steps from where the Visitors Bureau is and wraps around the corner before hitting a post. And I'm wondering, are you going to modify that so that the gate on that side can open fully, or what's the plan? I didn't recall, I may have missed it, but I didn't recall seeing anything in the discussion about modifying that railing.
Yes, the return on that railing will be removed, so it'll be truncated.
Okay, great.
Yeah, we had quite a discussion about that at the Kappa meeting, actually.
Yeah, okay, great.
All right, would anybody like to make a motion?
Well, I'll make a motion. I'll make a motion that we approve design review permit DRP 16-13 minus the, if I'm correct, or correct me if I'm wrong, but minus the planting, is that correct?
Correct. The reference to landscaping can be removed.
Okay, strike the planting of 2 new trees in lavender.
And we did recommend
Yes.
modification.
And the modification to the, let me find it.
Condition number 13.
Yeah, let's see, I guess I could say per staff. I know I wrote it down, but I think I wrote it down. Which one was it, number 13? Thank you. So the modification to 13 per staff. For DRP, I think I already said this, but I'll say it again, for DRP 16-13.
Okay.
I think I got it all.
I think you got it.
Yeah.
Yep. Do we
I'll
have-
second that.
Thank you. All right, any further discussion? Could we have a roll call, please?
Zabilla?
Yes.
Corbin?
Yes.
Jagiello?
Yes.
Quilisi?
Yes.
Burke?
Yes.
Nolan?
Yes.
Powers?
Yes.
Motion passes.
Great. Thank you all. I think this is going to be a beautiful addition to the city. Item 5 on our agenda is the accessory dwelling unit in ordinance TA 15-08, revising Article 7, Section 9, entitled Second Residential Units of Chapter 2 of Title 10 of the Ojai Municipal Code to establish revised standards in compliance with the state of California's new mandate regarding second units, and also considering additional local amendments to the city's second unit ordinance above the minimum requirements of state law. The proposed ordinance is exempt from the California Environmental Quality Act pursuant to Section 15061B3 of the CEQA guidelines, as the changes do not have the potential to cause a significant effect on the environment. I might take issue with that. The Planning Commission will make recommendations to the City Council. The City Council is the final decision maker on this item. The applicant is the City of Ojai. Could we hear from staff on this, please?
Yes, thank you, Mr. Chairman. As we noted at your last meeting and in your staff report, the commission has studied this issue a number of times in workshops and public hearings. At your last hearing, you gave specific direction to staff regarding a number of issues that have been addressed in your revised staff report, beginning on page 204, concerning lot size, living areas, number of ADUs permitted, guest houses, and so forth. The revised resolution, as well as a majority of the draft resolution, and the matrices have been developed by the city attorney's office. And with that, I'll turn it over to Mr. Summers to address any issues that you may have remaining. But we think that with these revised changes, we have responded to the commission's direction and recommend approval of the draft ordinance, and that you recommend it to the city council.
Thank you, Mr. Winiger. Chair, Commission, speak to a couple of points. The first one is an overall point in that we've had, as you know, a number of discussions about this ordinance, and we invite further discussion. We also hope to, in this conversation, distill this down to the final points, clarifications, and the final policy choices. And it is your role to make a recommendation on a policy choice, whether you recommend a single choice or you recommend a suite of choices that the council can then consider and make the final decision. They are the policymakers. Our job is to tee it up. Your job is to recommend. The council's job is to set policy. So bear that in mind as we go through some of these points. Some of them are straight policy choices, and others are cleanup and so forth. So what I'm going to do is just provide an overview of the changes that we made since the last time you saw this, and not go through the entire ordinance in full. But as any questions arise, please just please ask. So let me go through the changes, and then we'll available for all questions, and of course the public hearing. The changes we made. The first one is on page, and for this purpose, I'm going to look through the red line, may be easier to follow. The same text is in the clean version of attachment A, so I'm going to cite those pages. Attachment A, red line, page 4. For living area, we added the point that it's a minimum size. Living area means the interior habitable area with the minimum dimensions of 8 feet by 10 feet and at least 7.5 feet of headroom. We're keeping the point that it is of the dwelling unit, including the basement and the attic, but excluding a garage or any accessory structure. This is about the living area, the primary unit. This was added at the Commission's request and is intended to ensure that an area that might be conditioned and thus previously would have been defined as habitable or living area, but that is too small to actually live in, like a loft, say, or some sort of crawl space like that.
An attic, yeah.
Well, or portions of an attic, exactly. If your attic is sufficiently large to be livable, then it would count. If your attic is half height or a storage space, it doesn't count. The goal here is to include the area that you can actually live in, not area you can't live in. So we're open to revisions on that, but that's where that came from. The next one was on home splits. And this is kind of throughout the table. We added home split as a new column to the table as a new type of accessory dwelling unit. And just a little bit of background on home splits. At the moment in the code, home splits are a separate independent type of ADU or type of second unit using the current parlance. A home split is applicable in certain cases that are built into the definition in that you have to have a minimum of 650 square feet for each unit. The existing house has to be at least 2,000 square feet, be on a legal lot of half an acre or larger, and in one of 4 zones, RO half, RO1, RO2, and RO4. It's a relatively limited set of properties. And then if those are met, then you can have a home split dividing the house into 2 units with an expansion of the floor space by up to 10%, so it allows exterior construction. If that exterior construction is just to provide the kitchen or the bathroom, doesn't change the appearance otherwise, and meets the rest of the building codes and the development code standards. And that that's built into the current code. The table, the new column is added to reflect that and to allow it to fit in with the rest of the ADU, so it's a whole lot clearer than it is now. In that right now, that allowance is built into the definition in the definition section, built into the allowance for it in the ADU code, and built into a provision of the design review permit section that speaks to a home split that is single story or entails solely single story construction, does not require a design review permit, which means it's ministerial. A home split that does involve second story construction at present requires a design review permit. And the proposal that we've put based on your prior direction is to keep those rules the same. That's whether to keep them the same or not is a policy choice. We can change that as you would direct us to rewrite it to match what you'd like to recommend to the council. So that you'll see the far right column, far left, right column, is the home split column, maintaining the existing definitions. In light of the commission's direction at the prior meeting on page 6 of 14, the first page of the table, we've deleted the minimum lot size row, as the commission, as I understand it, is recommending to the council deletion of the minimum lot size requirement, meaning that ADUs of any stripe are viable in any zone, in any property in the R, OS, AG, or VMU zones, regardless of lot size. That's a policy choice. The commission can recommend that to the council.
So
Next.
long as the lot coverage and setbacks and the rest are still complied with.
Yes. And then the exception is, of course, the two types that are the third and fourth, the middle two columns, that correspond to Government Code Section 65852, Subdivision E, the allowance for an ADU by right that's conversion of existing interior space. In that case, you're using the existing lot coverage and the existing setbacks, whether or not those are non-conforming or conforming or non-conforming, they're maintained, because it's a sole conversion of existing interior space. For all of the other four types that involve exterior construction or new on-ground construction, the proposal on the table, and that's a policy choice, is to rely on the existing underlying zoning lot coverage and setback standards, and that's captured on the next page, page 7 of 14. Looking to the next page, 8 of 14, the number of units allowed on site row has been modified to make, I hope, clearer. Now it states number of accessory dwelling units allowed on site and is 1 across the board. The reasoning here is to reflect the fact that...
You said page 8 of 14?
8 of 14, yeah, in the red line version.
Oh.
There's, attachment A has 2 versions of the same document. One is clean, one is red line.
Oh.
I recommend we go through the red line, at least for this initial discussion, because it shows the changes.
Right, okay.
So we revised the number of accessory dwelling units column, row, to state 1 across the board. As state law is clear, if the requirements applicable to that type of ADU are met, the allowance is 1. Whatever the underlying zoning is, whatever the underlying general plan density is, whatever the facts of the property, you get 1 ADU on top. Now, whether you get an ADU of this type or that type will vary based on the facts of the property. At the minimum case in which, for example, you've already maxed out your lot coverage and you've maxed out your setbacks, you would only be allowed to have an interior conversion, but you're still allowed that 1 interior conversion, that 1 ADU.
Okay.
So we revised that to, I think, state that a little clearer. The next one that we revised, which actually ties into that, is the guest house issue. So that's on the next page, page 9 of 14. And this is another one that that is a policy choice. What I have revised here is intended to capture the current policies built into the code. There's no obligation to maintain those policies. What we wanted to do here was capture what the current policy is in a clear fashion. It doesn't have to remain that policy. You can recommend it to the council, and the council may change it at will. On guest houses, the basic rules of state law to set our floor are that the ADU law doesn't speak to guest houses. It doesn't prohibit the city from allowing guest houses in addition to ADUs. It doesn't prohibit the city from prohibiting guest houses in addition to ADUs. It is silent on the question. I think again, the rule would be, regardless of the situation with the guest house, if the ADU is proposed as sole conversion of existing interior space, then that's approved by right if you meet the fire safety standard and you have independent exterior access. The other types of ADUs, where you're involving new construction on the property, it's a policy choice. Does the city wish to allow a house, a guest house, and an ADU, or just a house and an ADU? Or perhaps you'd wish it to be a house, a guest house, and an ADU to the extent that you can fit all 3 of those on your property, given your lot coverage, your setbacks, pervious surface, etc. What we have worded now matches the current policy, which is that you get a guest house or an ADU, pick one. And if you have one, then you can convert it to the other, but you can't have both. That's the city's current policy that's built into section 10.2.1705. As I noted, that doesn't have to be the policy. It could be changed. And then the exception that is required to the current policy is the existing interior conversion. Right now, guest houses, not right now, as before January 1st, guest houses and ADUs were straight banned. Now, if you have a primary house and a guest house, you may add an ADU through conversion of the primary house if it's solely within the existing interior space, and you may maintain your guest house as well. That's the exception that must be put into the current policy. That's built into the middle two columns of the table. But the rest of these requirements are policy choices for the commission to recommend and the council to decide. The next one is septic and utility issues, and that one is on page 11. In here, we've added the final sentence that reads, notwithstanding the foregoing, if an ADU is proposed for a property with an existing private sewage disposal system, a septic system, then the ADU may connect to the existing septic system if approved by the building official and in compliance with applicable regulations. And on this one, that would allow septic to be continued to be used if the septic is sufficient to handle the added load. And that's a math problem tested by the building official. Otherwise, the present draft requires that the primary and the ADU be connected to the public sewer system and be shared and be commonly metered to all public utility services. I did receive a question on that point, and that's a policy choice. Do you want to allow, alternatively, at the applicant's option, to have jointly metered utilities or separately metered utilities? It's worth bearing in mind, of course, that the council at their meeting 1 or 2 meetings ago did directly state that they're not going to require, the city will not require accessory dwelling units of any stripe to provide for or secure will-serve letters for any of these utility connections. Bear that in mind. And that has already been implemented, of course. And as applied here, in most cases, the primary unit already has the utility service, should already have utility service. So requiring that they be commonly metered serves to create another way in which you avoid the trigger for a separate utility connection, and thus avoid the trigger for, avoid one of the ways in which the utilities might seek to collect additional fees under their skewed reading of their laws. But nonetheless, that does remain a policy choice. Do you wish to instead allow applicants to connect separately for those ADUs? That could be, again, recommended by the PC and proposed to the council. And then on fees, which is the next page, page 12 of 14, again, reflecting the council's action a couple of meetings ago, we've revised this to read, no connection fees, capacity charges, school district fees, or similar impact fees shall be assessed on an accessory dwelling unit, period. Accessory dwelling unit applications are subject to the city's planning and building administrative and permanent applications fees applicable at the time of the application. The prior language wasn't terribly clear. This is revised to reflect that the council has stated as a matter of policy that the city will not require impact fees for ADUs of any stripe, as is consistent with state law, which states directly the city may not require impact fees for ADUs of any stripe. City's acting both consistent with state law and consistent with the council's very clear direction on that point. What other agencies do is unfortunately outside the city's control. But we did want to add that second sentence to reflect ADUs would still need to pay the typical application fees. And then the last change I'll mention, 2 more changes. On the on the lot coverage, we remain looking for direction to bring back as a separate matter an item to establish lot coverage standards for those zones that don't have it, that are in the residential area. And I confess I don't have in my front of my head which areas in the residential zones lack lot coverage standards. The other change I wanted to point out that ties back to the guest house is on the next, on page 10 of 14, non-habitable accessory structures is a new column that we've added that states across the board, permitted in compliance with applicable regulations. Here our goal was to draw the distinction between a guest house and a gazebo or a garage, or a non-habitable workshop.
Equipment shed, yeah.
A work shed, some sort of building that is not habitable, that is, i.e. not, for example, for a work shed, it wouldn't be air conditioned, so it's not habitable. If it's not heated, it's not air conditioned, it's not habitable. Or a gazebo doesn't have solid walls, but it's still a building because it has four posts and a roof. Those structures shouldn't be barred solely because you have an ADU. That, as you'll see by the use of should, is also a policy choice the commission may make, the council may make. Staff does recommend that one be adapted to clarify the rules and to make ADUs consistent with the remainder of the code applicable to typical houses, which don't limit non-habitable accessory structures, rather don't prohibit them. They are limited by pervious surface and setbacks and the usual rules. And that's the end of my spiel. Available for all questions. And the chair should take the questions.
Certainly. Kathleen?
Sure. One question, and this is about the structures that you were just discussing. So for instance, I just want for clarification, if a unit has a restroom or a bathroom in it, is that considered a guest house? In other words, you could have a studio with a sink and a toilet, but not have a kitchen.
And not have a shower or a tub.
Yeah, not have a shower or a tub.
Yeah,
like a half bath or something. Yeah, I guess.
A structure like that, a studio with a bathroom would be under the current
Considered a
structure,
guest house?
would be a guest house or an accessory structure, which largely have an overlapping definition.
Okay.
It would not be an ADU. The ADU test
Not the
is
kitchen. Yeah.
exactly. You need
Exactly.
facilities for sleeping,
Okay.
eating, sanitation,
Mhm.
and the eating and sanitation means a bathroom and then kitchen space.
Right. So essentially, you could have your primary residence, an ADU, and a studio. If the studio did not have the kitchen.
And if that's the policy choice that's built into the guest houses.
Yeah, that's one of the questions.
Right.
Yeah.
Because at the moment, guest house is any structure that's habitable. So the studio, for example, if it's
Could
air
be.
conditioned and heated and has a bathroom, that's habitable space. That would qualify as a guest house.
Mhm.
That's the exact question on the table.
Okay.
One of the exact questions.
Okay.
Is do you want to allow those in addition to ADUs
Okay.
in all cases or some cases, not all cases?
Thank you.
Tester.
I think the way the county defines that is the size of the bathroom. As far as the studio goes, it's a half bath versus a bath with a shower in it. I think we can, I think it was our intention to allow for a accessory building, i.e. office or workshop, that's habitable. I think my proposal is to limit that to a half bath, which makes it very unattractive to a studio, to a living environment, not being able to shower in it, and allow that to happen over and above
As an
ADU,
additional
as
building.
an additional building on site to an ADU.
Still subject to the setbacks law,
Yes,
lot
yes.
coverage and
Mhm.
and all the rest, yeah.
All right.
I would favor that.
Mr. Quillen.
Yes, sir, thank you. Mr. Summers, on your red line version, page 10, you just spoke to the non-habitable accessory structures. Just so that we don't get into an argument with any other jurisdictions in the county, I'd like to suggest that instead of saying applicable regulations, that it say applicable city regulations. Then we're not going to.
We can certainly adopt that.
We're not going to run afoul of the fire department, for example, that way.
Well, and to be
Fine.
clear, the fire department is only allowed to enforce the regulations the city has adopted. They can't enforce their own regulations.
Okay, and the same is true of the utility?
No, that's different. When the fire department is permitting a building, they are only allowed under the health and safety code, and I can get you the citations, but I don't have them off the top of my head. They're only allowed to enforce the fire code and the building code as they are adopted by state law
As you
and
said
as
in
the
the
city has
previous, yes.
adopted
Okay.
amendments. They can't enforce the amendments that were adopted by the county and some other cities. They lack the power to do that.
Okay.
The utilities are different. Utilities have independent power. They're not enforcing the building code. They're requiring payment of utility fees and payment of their charges. And they're allowed by their own laws to impose their fees, or by, in the case of Golden State, by the PUC laws and the franchise the city granted them. But say for the Ojai Valley Sanitation District, which is the main one at issue in this matter, they have their own law that lets them impose their fees. Now, The city's council's position, as articulated the other day, is that that fee is unreasonable, and the city will not serve as the is not going to force anyone to pay it. The sanitation district retains independent power to enforce its own laws, and it has its own choices. And for anyone who's listening, that fee the sanitation district is imposing may well be vulnerable to challenge. Consult your own lawyer. But I'd be happy to add that to that row in compliance with applicable city regulations. And for what it's worth, any time in this code that I see the phrase applicable standards, applicable regulations, I take that to mean applicable city regulations. I read it as built in.
That's fine. Great. You're the lawyer. I did have a question on your fees paragraph. It says no connection fees, capacity charges, school district fees, whatever, will be assessed on an accessory dwelling unit. By the reasoning you have just stated, you mean no fees will be assessed by the city.
That's implied.
It's implied, it's not necessary to state it?
It could certainly be stated for clarity. I see no harm in stating it. In fact, it might solve the problem that some folks would face of saying, the city said I'm not charging fees, why are you charging fees? And the answer is they're an independent sovereign.
Yeah.
So I would suggest for that one, we add at the end of that first sentence.
Added by the city after accessory dwelling
Exactly.
unit. That, I think, would solve that problem.
Agreed. That's good. That's a good recommendation. Thank you.
Back to the requirement, this is page 11, paragraph 1F. Is it? Yes, 1F, that had to do with the common metering. I think that there is one thing that is anticipated, perhaps even hoped for, by this body. I'll let my fellow commissioners say if they agree with that, and by the city council, that as we have new legal ADUs pop up, by whatever means they do, that there is a hope that these will all become long-term rentals. And my thought, if I had such a structure on my own property and I was intending to rent it to someone, I might want to have them pay for the water and the electricity for that residence. And so I'd like, if everyone agrees, I'd like to see that paragraph 1F modified to say that common metering or separate metering is at the option of the homeowner, of the property owner. Is that?
I had the exact same, excuse me.
Great.
I had the exact same comment that.
Great.
You know, it wouldn't be required, but if you wanted to do it, you certainly could.
Yeah,
Right.
there's obviously benefits and costs to doing that. But I think we ought to leave people as much leeway as we can and let them make their own decisions for good or bad.
That's certainly a
Yeah.
reasonable option to recommend, and folks should be aware with that choice that applying for that separate connection could trigger those fees.
Yeah.
But that would be their choice.
Chester?
I have a question about the ambiguity around a separate entry. In the current code, I believe there's it suggests, and this happened to me today at the city in going over a second dwelling compliance. Is it true that a second dwelling has to have a separate entrance but cannot share an entrance within the same structure? For instance, let's say you come through a garage entry and there's a hallway. Go left, go right. Those are two doors. They're connected by a living space. So they're connected by a similar space. I'm trying to get some clarity on what the code is, because staff seems to be interpreting as though you cannot have that condition.
As I read the state law, that is not the definition of an ADU at the moment. An ADU is defined as complete independent living facilities. I read that as independent exterior access. That's also built into the requirement that to have the ADU by right, notwithstanding any other rules, inside an existing interior conversion, it expressly states that it must have independent exterior access.
Exterior, well, it does.
That could be the garage door.
It does have exterior, it has a door on the outside as well, but on the inside, it also has a shared hallway.
That goes back to the complete independent facility.
But
Has
they
to be
have
walls, not
independent doors.
There's still if there's a way to walk from one unit to the other inside the building,
Why is that prohibited? Just what is the
If they're
reasoning behind
lockable?
that? Yeah, if they're,
So-
look, any apartment has a hallway and all the doors are accessible on the hallway. It's logic in any apartment, right? So why would it be illegal for, have a hallway where you have separate doors with separate locks? Makes no sense to me. I mean, why isn't that allowable? And why can't we make it allowable?
So there's a couple of responses or points to bear in mind. The first answer is that in terms of what we have to do, state law defines it as complete independent exterior access and complete independent living facilities, which I take to mean two doors, exterior doors, one each into the building, and no doors between them, even if they're locked or controlled by both sides, something like that, like you might see in a hotel. But that's the default in state code. That's what we have to allow. State code is also clear that the city can adopt additional standards or relax standards, or rather, adopt additional rules that relax the standards. Thus, the city could allow ADUs of that stripe. That's a policy choice.
Yeah.
And it's worth pointing out, as was noted in the comment letter from Ms. Spiller, there is a separate provision in the state code that allows what are called junior ADUs, which is a separate may but not required to set of rules. The city may but is not required to permit junior ADUs. In a nutshell, a junior ADU is separate living and sanitation, but may share cooking facilities. In other words, and they may have interior access to each other. So that the model is, if a house front door into the house, you go to the back, one kitchen, shared kitchen, you go to the back, and you have a back walled off with a door that's the bathroom and the bedroom or a studio. That model is the junior ADU model.
Sounds like a rentable ensuite bedroom.
Essentially,
basically.
yes. Exactly. And you put a lock.
I would think people here in the city would want to have the option to have that sort of thing.
Absolutely, and there's so many good reasons for it. And you're an elderly, your mother, your relative that's ill, and you don't want to have to go outside into another outside door when there's two existing doors that could be connected by a hallway. What is wrong with that? I just see that's a ridiculous code, and I would like to change it myself. I would like to make a suggestion, or if you can give me some kind of guidance on how to structure and where that would be placed in the ordinance. I would like to allow for or delete the necessity to have exterior entries only. I would like to have the option to have interior entries with separate doors. That seems totally reasonable, especially if it's an ADU connected to a house.
But you mean a full ADU, not a junior ADU as well?
A full ADU. Why a junior ADU? Because it doesn't make any, why limit it?
Yeah.
I mean, it doesn't.
So-
Well, there are different classes of, there
You
are
could
different
create
classes of accommodations
Yeah,
in the
but-
state law. So maybe we need to add another row to the table to include junior ADUs as well as making the modification that you're discussing.
Yes, and I would highly recommend it. I just don't see any point in that rule. It's a limitation, and it really does impact quality of life, and it makes no sense. Since every apartment you can see has a shared hallway.
And it's worth bearing in mind that apartment buildings are also subject to the full multifamily building code,
Right.
which most of these buildings can't meet.
Right, but still.
Apartments
I mean,
have firewalls
but-
between each unit, whole variety of standards, and ADA access.
So you have
That may not be the best model.
But you have a fire door between the two units.
And you need
just
a firewall.
You just require that. Well, that's 5/8 drywall. That's no big deal.
Right. So that's the other point that's worth bearing in mind that I have seen arise in some other cities is when you look at allowing junior ADUs, or even when you look at allowing existing interior conversion, residents need to bear in mind that it's not so simple as cutting a hole in the wall to create, walling off the door and cutting a hole in the wall to create the door. You need to build a firewall around it because you have to have that firewall separate. You also have to divide up your utilities.
Right.
So we can certainly do that. My suggestion would be that
You said you must divide up your utilities?
the circuits. You don't have, in other words, you can have
okay.
one line from the telephone pole to the house, can be one line or two lines.
Separate breakers.
But inside
for
the
two.
house, the breakers have to be separated. You can't have If I'm living in the second unit and I trip the breaker, it can't kill the power to the main unit. They have to be divided.
To any part of the main unit?
Correct.
Yeah, okay.
And that's always been handled by the building code.
Yeah.
But yeah, they do have to be
Which is a
separate
bad matter.
utilities. And it's one of those ones where, unfortunately, the people who were writing the ADU law that took effect January 1st did not speak at all to the people who were writing the new building codes. It may have made sense
Naturally.
to allow some of those circuits to be joined and allow some other things like that. But they didn't. They didn't speak to each other. The wisdom of Sacramento. To answer your question directly, I think you can do it two ways, two choice sets. One would be to recommend that we bring back, and I would suggest we do it as a separate item, junior ADUs. I'm not sure I'd add it directly to this table because it's a fairly different concept in the state codes, and it's a fairly different type of unit in that it doesn't have separate independent kitchen facilities. It doesn't meet the existing definition of ADU here. So my suggestion is that you direct, if you'd like, direct staff to bring back a meeting as soon as time permits, a junior ADU item. And it may make sense as well it may make more sense perhaps, given that that's not required and is a straight policy choice. As you recommend the ADU ordinance to the council, you also recommend consideration of junior ADUs. And then the council can decide, yeah, that sounds good, let's go have the PC look at it. Or, yeah, I don't know. So maybe as I sit here thinking, speaking and thinking at the same time, I would recommend perhaps that approach, that we get the council's approval on the concept of junior ADUs before we spend the time to go
So is
put
that
the
the-
ordinance together. So that's piece number one, would be the state code, fit the junior ADUs rules. The value of doing that is that to some extent it lets you out of these building code standards. The junior ADUs have some exceptions to the building codes built into them.
Will that apply to a standard ADU, though?
No, that's to the junior ADUs under the state
Right,
code.
so
The
how
state
do-
draws a clear line between regular ADUs and junior ADUs.
So how do we adjust a standard ADU?
Right. So to adjust a standard ADU, you need to adjust the definition. And the way to do it would be to provide, as an addition to the definition,
Where are you looking at, Matt?
I'm looking at the red line version of attachment A,
Page
page
three.
3, section 10-1709, subsection B1, definitions. Add a sentence at the end that would say, an ADU may have, or must have,
Sounds like something you'd want to add at the next to the last sentence.
yeah,
Because
before
the stuff
the,
about living, sleeping, et cetera, still applies, but
agreed. Yeah, an ADU must have either independent exterior access or,
Independent interior access. I mean, that's a very simple way to say
yeah,
it.
independent interior access works,
Separated by the proper fire codes.
which apply by default.
Yeah, anyway.
Right.
okay, so at the end of that sentence where it says living facilities for one or more persons, if we added the phrase having independent exterior or independent interior
Entries,
entries.
I would use access perhaps.
access.
Access, great.
And
Yeah.
that would work to create the model that you see in some older buildings. Door from the exterior into a little foyer, 2 doors, each independently locked.
Absolutely. That's the condition we have right now in an existing project that we're working on. It comes off the garage, comes into a hallway, you go right into the main unit and it has a door, you go left, you go into the ADU unit. And
And
it
with this
seems
definition,
completely-
that'd be legal as long as you put in locks on each of the doors that
Right.
don't,
Yeah.
the key goes to the unit.
Yeah.
Or the landlord, of course.
And you still have to do the firewall then.
The firewall's,
that's
that's going
by
to be
default.
required by the building code.
That's part of the BAB's jurisdiction, but,
And more importantly, the states.
yeah, and the state.
We
Great,
can't relax firewall standards. We can only increase them.
yeah. Well, that's a good idea.
All right.
All right.
Any other?
I've got a couple of more. I think I'm struggling with attic. I know we talked about attic today. It's really hard to define, and I think you've kind of made an attempt at it. But let's say it's a 12-12 pitch. And there's part of that attic that is considered living. So I guess you would measure that at the 1212. You go to the 7.5 feet section, and then between that point and that point, you create a box, and that's considered habitable.
Virtual box.
That's how you would apply the definition that we've got here.
Okay, I guess that's definable.
Oh, great.
Office, garage. That's all mine.
Unamas? This is one of the questions I submitted earlier. I see the new state law, 65852.2 B1 E and F, puts both a 1,200 square foot and a 50% of existing living area limit on an attached ADU, but only the 1,200 square foot limit on a detached ADU. And I think our table right now puts the 50% limit on a detached ADU as well, and I'm curious why, since that's a restriction beyond what the state law requires. This is on page 8 of 14 in your red line version, the top row. And it's uniform across the board with 1,200 square feet or 50%.
Because that's what we talked about repeatedly.
Yeah, and all I'm making is the point that the state law requires that for the attached ADUs.
Right.
It does not require it for detached ADUs. And if we simply leave lot coverage, setback, et cetera, on detached ADUs, I think we give homeowners more flexibility in putting together their own ADUs. So I would suggest deleting the or 50% of the living area for columns 1, 2, 5, and 6, depending on what the rest of the commission has.
As I see it, this point is a straight policy choice. The commission may recommend it, and the council may act. The reason is that the language that you quoted is in Government Code 65852.2, subdivision A1, A1.
I think it's B1.
D, Roman 4 and 5. There's also language in subdivision C that says a local agency may establish minimum and maximum unit size requirements for attached and detached accessory dwelling units. It goes on to state that no minimum or maximum size that's based upon a percentage of the existing dwelling shall be established by ordinance that does not permit at least an efficiency unit to be constructed, which is a minimum 250 square feet. And that's captured. If we had a house that was sufficiently small that half of it blocked that, then we would up it for that. But as I look at it, what's left is a delta that's a policy choice.
Right.
So what you're recommending, you could make a motion.
I'm suggesting a slightly modified policy choice.
Exactly. You can make that in a motion, and it will be voted as it votes. And this might be one where the commission you vote, and then you forward whatever the vote is, or else you perhaps forward it as a choice to the council and point out to them, you could choose this, you could choose that. The commission couldn't agree, or vote, and vote as you vote. And we'll certainly, when it gets to the council, we'll note that the issue, whatever the vote is, we'll note that point in the issue in the discussion, because I do recall we had extensive discussion at that point.
Yes, we did. Chester?
Yeah, I'd like to address that point. The reason for the 50%, Steve, is a scale. It's when you go to a project, you want to create architecturally pleasing structures, and it's about scale. You go in there, and if you have a 1,200 square foot house, and you're being allowed to create another 1,200 square foot guest house, it's just out of balance, and it's just naturally out of balance. It's out of character with what we have. Now you've just did a lot split. Really, you've subdivided your lot, and without having to go through the subdivision laws. Well, not necessarily, because you can't sell it as a separate unit.
Because the ownership is still common.
Still, it's to me, it's out of scale architecturally, and the 50% rule allows for scale that makes sense. And if you just think about the size of the lot, if you have if you have lot coverage, setbacks, and that scalability, if you're in, for instance, Persimmon Hill, where most of the houses are 3,000 plus square foot, they can all do a 1,200 square foot house, guest house, no problem.
Agreed.
And its scale, it makes sense there. Whereas in other areas of Ojai, they may have big lots, but they could put a small house. That's the scalability. They have a small house for a reason. They could change that small house into the guest house if they have the ability to build a guest house at 1,200.
As long as that primary unit is no larger than 1,200 square feet.
That's correct. So to me, it's a scalability, it's an architectural element that I think will keep Ojai's character in place. I think you start to get, you don't put any rules on that, you'll get overbuilt structures on lots, squeezing them into sites that are not architecturally balanced.
Thank you. Bobby?
Yeah, and additionally, we agreed to use the 50% instead of having a minimum lot size, so that more people had the option to build the second unit. And that would encourage smaller ones in the hopes that there'd be more affordable housing.
Also, I'm opposed to, the council's going to really go over that item in length, I'm sure. So I'm not opposed to,
Okay, well,
I'm not opposed to submitting, options to the council, because I'm sure they're going to have a heyday with that one. So.
Yeah. Kathleen?
Yeah, I just wanted to comment along the lines of what Chester was speaking about, the scale, the massing, but there's also a sense of hierarchy. And if one unit is larger than the other, that's kind of basically like the primary unit, and the ADU becomes the secondary unit. So I think it just makes sense, and once again, it helps to maintain our downtown feel, sense of place, what's existing at the moment. I mean, even though I know that potentially that, it could span more structures, but it still looks at that sense of hierarchy.
Right.
I'm glad we're having this conversation, because I've been reflecting on on the motion and the vote we took last meeting to dispel with the minimum lot size. Kathy wasn't here for that vote, and I've been reflecting on that, and I'm not sure I'm not aligned with the recommendation of throwing out the lot size. I would still like to see 50% and a minimum lot size. And the reason is this: in the more crowded areas of Ojai, like Drown in that area, south of Grand, if you have a 6,000 square foot lot, yeah, I understand there's setbacks and things that would limit the size. But that doesn't address the overcrowding and the parking and the safety of the children in the street, and just footprint on the land of paving over soil in general in areas that are already condensed. So I just wanted to put that on record, that even though, last week I voted in agreeing to dispelling the minimum lot size, on reflection this last week and really looking at it, I would rescind my opinion on that, and would like the council to really look at keeping the lot size minimums in place.
Thank you. Kathleen?
In rebuttal, I'm in agreement to not have a minimum lot size. And I actually see the benefit of having infill in the downtown area. I mean, I'm definitely into having open space, but I'll tell you why. Number one, actually, I just read a report today, and it was from the transportation organization for the entire country. And it was talking about infill and accessibility to amenities and people walking and biking, where essentially the more you have downtown within a walkable distance, the less traffic or parking you may have. I mean, we can't tell someone you can't have a car, but if it's easy to walk and it's accessible, it makes more sense. You also have like level of service. The roads are there, the utilities are there. I mean, I know in Ojai we're kind of built out. I mean, it's kind of a lot here and a lot there as compared to the county in the valley area. But if you concentrate it more in the center and the infill, it just makes more sense because of the accessibility, potential for reducing traffic and what have you. The other thing that I look at, and I was not at the meeting, but I did listen to it. I watched the video, the recorded video. I lost my train of thought there. What was I going to say? Well, I'll come back to it, but go ahead.
I see your point in terms of walkability and accessibility to the amenities in the town. But that doesn't address the quality of life of having too many mice in the same cage and paving over, soil, which is permeable surface, and just in general connection with the earth and what that, to me, a big part of the allure and character of Ojai is our open space. And even though you may have a neighborhood, doesn't mean there isn't open space in the neighborhood. You might have a 6,000 square foot lot that has a 1,400 square foot home, main residence, which leaves for quite a big, nice backyard. And I don't necessarily think giving permission to build ADUs on those smaller lots is a wise way to go.
Thank you. Commissioner Zabala.
Well, of course, I concur. I've been very clear on this point as well, that I support minimum lot sizes and the 50% rule. I was sitting at a board of realtors meetings today with the most seasoned real estate professionals in the city, and they're pretty horrified at the idea of losing the minimum lot size. They feel that we are simply going to absorb impacts and not touch the affordability issue. That's their opinion, and I concur with that. I think at the very least, I do hope that the staff report reflects that the commission's very split on the minimum lot size when that does go to city council. And just want to reiterate that the 50% rule is the only potential possible way that any affordability will be created by trying to constrain the units from being too large. And I think that I'd also like to suggest that just for ease of understanding of what is and what isn't possible, I'd like to suggest that we eliminate the language that says the attic is included in the calculation for the living space, the 50% of. I think that that's going to be very confusing. I don't know how that's going to be easily managed at the staff level to process that kind of an application. It would be much better for an applicant to look at what their legal square footage is, which is an easily accessible number, and say, I can do 50% of this on an ADU. I just think that that's kind of a no-brainer. So I'd like to suggest that we clean up the language to say
Can you
that
cite a
it's-
place?
Sure, on the maximum floor area
okay.
size of
Yeah,
unit.
okay.
That we would say 50% of the existing living area of the legal primary unit, basically, period, or primary unit, whichever is smaller, but not inclusive of a basement and an attic.
Or you could say excluding.
Excluding the basement and attic, yeah, whichever is
If the
smaller.
basement and attic are habitable and living areas, though,
I mean, currently already,
if they are of a sufficient size, as we discussed earlier, 7.5 foot ceiling and some amount of floor space, I don't see any reason why that shouldn't be counted.
Well, only,
But-
because that space goes up. We're talking about scaling to the floor area of the existing dwelling. It doesn't make intuitive sense that we would be including a structure.
Potential space, that's what you're saying.
Potential space, yeah.
That's the issue, and I kind of agree with that, because if it's still a basement, first of all, we don't have that many here, so let's not
Agreed.
get too carried away on this.
There's
And
one
we-
on this project on
Yeah,
Libby.
I know, but there's not that many. And that's a large house. That can accommodate just about anything. So, but attics, I would say the same thing. There's not that many 12 pitch roofs in the city of Ojai.
I have one, but-
I have one myself, but it's a living space. It's part of my living space upstairs. So, but in most cases, they're not sitting there. If they're 12 pitch, they're not sitting there vacant. And if they're conditioned space, then obviously they're counted. But if they're using as attics, so when they submit their plans, it's kind of like, it's either being habited, it's either remodeled and being used as a space, or it's storage and it's not.
Right, it's
So
either
I-
already part of the legal square footage of the house or it isn't.
Yeah.
Yeah, and I may not agree with you completely in principle, but on the legal language, I think the change that we saw to the definition of living area already will allow for counting any potential living area in basement or attic.
Yeah, but counting the potential living area is not real accurate in deciding the
But-
50% rule.
But that's the definition that he modified for living area.
I
There's a
understand.
point to bear in mind on this minimum sets of state law here. The state code defines living area as the interior habitable area of a dwelling unit, including basements and attics, but does not include a garage or an accessory structure. Because that sets that definition, if we subtract off basements and attics, it makes the living area smaller in some cases. It reduces the available unit size, and thus sets a more strict standard than the minimum state bar. So I don't recommend doing that. You can certainly disagree with that interpretation of the code, but my recommendation is that we leave it in place as living area is the dwelling unit, interior habitable area, including basements and attics, minus garage or accessory structures. So my recommendation in terms of the way to build in the reality that you don't want to count area that nobody can use is to build in this size-based definition. I know it's more complicated, and I know it's harder to create some implementation issues, but I just don't see the allowance in the state code to.
Limited number of instances.
Agreed, but
Yeah.
the principle stands.
Certainly.
Whichever way we go, the principle stands. It doesn't depend on how many instances in the city exist that demonstrate the principle.
Correct. And as any of my comments is my opinion, you're welcome to
Sure.
do otherwise. But that's how I read the law, is that I don't think you can drop that out, but you could certainly tweak with that language.
With the 50% language?
No,
With
with
That's all
the-
we're talking about.
In terms of, I don't think you can delete basements and attics from living area.
Okay, but that's not.
So long as they
we're-
meet the definition of living area.
Correct. In other words, so you can tweak the 50% language, but I don't think you can, in that language, I don't think you can delete inclusive of basement and attic. I think that's built into the definition of living area, that's built into the state code. Does that make sense?
That's why we added the standard in the definition.
I'm seeing a lot of confused looks. Let me clarify.
How is that practically, I mean,
It's going to mean that when someone applies or when someone is trying to figure out what they want to do, they're going to have to
We're gonna have to
evaluate. I think maybe.
If
Right.
an applicant wants to include some attic or basement space, they need to demonstrate that it is, in fact, within the definition of living area.
Correct. They would have to provide the floor plan and a section that demonstrates that there's at least 7.5 feet of clear area, clear height, as well as the minimum floor dimension.
Ray, can I'd like to interrupt here for a minute. This is a public hearing, and I think we're going to keep on debating this for a while, but I have a speaker's card from Mr. Ulrich, and I kind of wanted to see if there were any other public input that we wanted to get on this. And I think we'll come back to our debate here after we've listened to that. So, Mr. Ulrich, I'm going to open the public hearing and look forward to hearing from you.
Good evening, William Ulrich, 487 Gridley Road. As my commented at the last meeting, my observation, many of the efforts and discussion points this evening appear to me, and certainly sound like, means of managing the growth of ADUs in the community, and that is subversion of the intent of the state law. And I'd just like to point out a couple of, and then I have some questions that are not clear because, which I'll come back to, but as things exist now, when someone comes in and applies for an ADU, a building permit is issued by the building department, and yet this is, according to my understanding from Mr. Summers' earlier recitation, the community development department is responsible for ADUs. So not only is that confusing to me as someone who's been actively engaged in this, I would submit it would be very confusing to an applicant. So what's going on with that? There are no ADU applications when someone walks in. I've requested one online. There are only building permits issued by the building official or the building department, subject to building official review for compliance with the building code, perhaps, but this is not only 4 months, nearly 5 months into this program, completely non-existent, at least from my perspective and my experience. But I'd like to once again read from the actual text of Senate Bill 1069. An accessory dwelling unit conforms to this subdivision shall not be considered to exceed the allowable density for the lot upon which it is located, and shall be deemed to be a residential use that is consistent with the existing general plan and zoning designations for that lot. The accessory dwelling unit shall not be considered in the application of any local ordinance, policy, or program to limit residential growth. This concern and this fear, anxiety, I'm not sure what it is, regarding loss of open space. When you're discussing backyards on 6,000 or 7,500 or 10,500 square foot lots is, while apparently well-intended, the actual application and the way it would play out in real life is not to be an impact or even a noticeable addition to the city's paved over space. Now, from a practical, perhaps drone perspective, aerial, okay, yeah. But, we still have a lot of empty lots in this community that are zoned commercial that are not filled in. And if we're looking at green space, until it turned brown and became a fire hazard, we had plenty of that. And it doesn't seem that we're making much inroads in minimizing or using that commercial space. But having said that, and I see everything's going orange and red on me, I have to ask a question specifically regarding the living area definition. 8 by 10 feet and 7.5 feet of headroom. That's not contained anywhere in any of these state ordinances. The state statutes, Senate Bill 1069, that is a Title IX distinction. And last time I checked, and I will be abundantly corrected, you folks are engaged with, and your purview is Title X. So the inclusion of this limitation is unreasonable, and I believe it is, once again, it subverts the intent of the state law. Relative to some of the other elements that are in the resolution, I have to ask a couple of these questions which are somewhat applicable to let's see here. They come after the standards and the standards in common. 1D, Accessory dwelling units, including a portion of a pre-existing primary residential unit that would be incorporated in an accessory dwelling unit, shall comply with the minimum standards of Title 24 California Code of Regulations, the Uniform Building, Plumbing, Housing, Mechanical Codes, National Electrical Code, Fire, Health, and Safety Code. Excuse me, that absolutely lacks sufficient specificity. Reading this, I'm assuming the currently adopted, be that 2013 or 2016, editions of these codes. In other words, current codes, and ADUs are not responsible for those. That is a compliance issue that last time I checked was Section 1941 of the State Building Code, which is minimum habitable criteria. In other words, if you can manage a chicken coop to meet the criteria contained in Section 1941, it will comply as an ADU. That is so broad that any building official or inspector that I know would look at it and say, current code edition.
So, Mr. Oak, you've like gone twice over the normal time. So.
Well, actually, I've only gone a minute and 7 seconds, but you know, you did, Mr. Merck did ask for my comments, and
yes.
While the 2 minutes doesn't quite do it, I'll leave it at that. Thank you.
Thank you very much. This is a public hearing. Is there anyone else who'd like to speak on this? Sure. Yeah, come on up. Just state your name and address for the record there.
Okay. My name is Michael Haley, and I live at, where do I live? 1577 Kenilworth Street. And, you know, I wasn't planning on coming to comment, but I just kind of wanted to come and see what's going on down here. I've never been to a planning commission meeting before, and mainly I have a question, but since I'm up here, I wanted to mention that I'm very impressed by this. It's a very important issue. I don't have a big, strong opinion about it yet. I'm going to read up on it, but I just appreciate, you know, I'm impressed by the seriousness that you're taking in it, and you're really considering all the details, and it's much more than I expected. So, you know, who criticizes government? We got a pretty good government going right here, and I can see it. The question I have is, can you build more than one ADU on a single lot, so there's just a one limit? Yeah. I guess my point of view when I'm listening to all this is just thinking, what if it was both my neighbors, you know, decided to build one? How would it impact me? That's what I think of. You know, and it will have impacts on people. So just hopefully considering that. All right, thank you.
Thank you very much, Mr. Haley. Anyone else like to speak on this? All right, I'm going to close the public hearing, and we can get back to our discussion. I would like to echo Mr. Haley's comments. I'm just flabbergasted that the state feels we don't need any impact fees on these, because I see this as a huge impact on the city, but apparently it is out of our hands. Anyway, any further discussion on our item here? Ray, you were just about to say something.
I need to be prompted to do this.
We were talking about lot size, lot coverage versus minimum lot size.
Perhaps
All right.
I could help.
All right, jump right in. Mr.
I think that if the members of the city council take a moment to look at the proceedings that we have here tonight, they will recognize that there is a division of opinion on this commission about the 50%, about the minimum lot size, though we have voted on both of those things already. One I liked, one I didn't, but it was kind of the consensus of the commission with the minority report on each of those topics. I did have one more question.
I remembered what I was going to say.
Oh, all right, please go ahead.
Thank you for that. It did have to do with the inclusion or exclusion of the attic and basement, and I'm trying to get clear on this. So if someone has an attic that is not built out, that is potential to be built out, Mr. Summers is advising to keep that attic as part of the habitable area. Is that correct?
State law.
By state law.
I think it would depend on, you use the phrase "not built out."
Yeah, not.
As I look at it, habitable means it's habitable. It's finished walls. The insulation is closed off, and it meets this height limit we're looking at. I don't think that definition of a habitable area includes an attic where the insulation is exposed, the rafters are exposed. I don't think it includes unfinished attics, in other words. I think it includes, it's a two-part definition. Is it habitable, and is it primary unit or basement or attic? If you have a attic or a basement that doesn't meet the, or for that matter, if you had a room on the main floor that didn't meet the definition of habitable, i.e. had exposed insulation, exposed piping, didn't fit what the building code and building inspector would define as habitable, then I don't think that would be included because it's not habitable, even though it is an attic that might be tall enough. Does that perhaps provide some clarity?
So there's no way around that. Let's say someone puts up, they finish their attic out and they put up walls just so they have a cleaner space to store a bunch of boxes. There's no way around saying, in terms of building an ADU, to not have that included as part of.
I don't read the state code to subtract that area if it's built out and if it's of sufficient size.
What if it's not built out? What if it's just raw attic space?
Then I think it's not habitable and doesn't count.
And it doesn't count in this.
His example, it's built out.
No, I know, but that's what we were trying to get at, I think, with this.
Okay. So it has to fit the
Originally.
definition of habitable. So if it's just raw attic space, then it would not be included because it's not habitable.
And that's in the definition of living area that's in the proposed
And then look here,
text
we define
amendment.
habitable
Right, and the
space.
only place it
After we finish
applies
this, we
is
should
in the
delete that.
calculation to determine the size of the unit.
Right,
We should delete that line.
right.
And there's one point that I think we should, there's an internal conflict that we've just realized that I think we can fix. If you look up two definitions from living area, habitable space is defined as an area within a building designed for general living, sleeping, eating, or cooking purposes. It's not necessary that a room or area be finished in order to be considered habitable space. I'd suggest we delete that second sentence to capture the point that I think is built into state law, which is that if you have a house with a finished basement and a finished attic, that space counts against the half. But if you have a house that has an unfinished basement or an unfinished attic, it's not habitable, it doesn't count. But I don't think state law lets the city subtract off the attic that's finished or the basement that's finished from the house size.
That makes sense.
That's clarity, I hope.
Okay.
So it has to be habitable space.
Right.
Another couple of questions, if I might, sir.
Two more.
Yeah. Well, this just brings up
We'll just keep
another,
going.
this brings up another question. If I have an unfinished attic and I wish to finish it, what are the restrictions on me under the current code? Probably have to get a building permit to
If you have a,
do walls or something.
right, if you have an unfinished attic and you want to finish it, you need a building permit for the interior work.
Okay, same
if
with the
it-
basement.
Same as the basement.
And once that's done, if it's then habitable space, it falls into these definitions.
Right.
Okay, great.
And it's worth pointing out, it might also need an electrical permit, a plumbing permit, whatever else would apply.
Be
And that
structural.
building permit would be looped through the planning commission to do a zoning conformance.
It'd have to be built to code.
You'd have to build it to code.
Because it's new.
Exactly. New wood hammered up.
Current code.
Right, that's worth pointing out. It's
Right.
current codes that are tested for these. The allowance for existing codes or prior codes is for second unit or accessory dwelling unit compliance program units.
Those are existing units that may not conform to the current code, yeah.
Right, those are existing units that existed as of
Yeah.
July 20,
Whenever they
15,
were, whenever. they
July
were-
2015, there's an exact date that I forget off the top of my head. Those ones don't have to meet current code, they need only meet minimum habitable code. But any new built ADU or new conversion of an ADU that is not a compliance program, legalization of an existing unit, must meet current building codes.
Great, I have no objection, I don't know about anybody else, I have no objection to deleting the second sentence in definition 9, habitable space. I did have one more question, and I do this only because I think we need to be consistent in our nomenclature here. In definition number 10, home split, it occurs the phrase living space. In definition 11, it says living area. I'm not sure which one is more proper, but I think they should be the same.
We'd recommend using the state code's language of living area.
Living area, okay, so that would be just modifying one word in definition 10.
Okay, thank you, Kathleen.
Just one comment. Mr. Summers, when we were starting the discussion this evening, you had mentioned, I believe, that the one area we hadn't addressed yet was the lot coverage standards for zones that were not listed. Is that, did I understand that correctly?
Thank you. Oh, the A.
There are some, yeah.
Right.
Yes, that's, as I understand, it's the ag
Okay.
zone and the open space zones
Right.
that lack
Is
lot
that
coverage standards.
something that we need to address tonight, or is that something we would just, when we take it to city council, just say we haven't addressed that yet and it still needs to be
Along
looked
with
at?
the junior ADU topic, yeah.
Right, and possibly even tiny homes with the junior ADU.
Let's don't get started on time.
No, but that's separate.
As long as they're not on wheels.
Those would all be things that would be part of, I think your recommendation to the council would be adopt this ADU ordinance and then direct us and you from the council to work on lot coverage standards and if you desired junior ADUs or tiny homes.
Yes, Commissioner Zavala.
I'd like to clarify the point on, I want to clarify this language based on what we just talked about with the 50% rule. And then I'd like to, I don't know that we need to take a vote, but I'd like to at least poll the membership because although I think that there was more of a split on the minimum lot size, I think there is much more consensus with regard to the 50% rule. So I'd like to clarify that language first and then, and make sure that we're all talking about the same thing, that the 50% is calculated on the, I don't know how we want to say it, that we don't run afoul of the law, but the 50% of living area is calculated on the currently permitted space, I mean, what would be the most effective language to use?
It says existing living area right now, and if you go back to the definition of living area, it's that habitable space that we've been discussing.
But because it says inclusive of basement and attic, I think that's going to be, I think it's confusing language,
So
is all
long
I'm
as they
saying.
are
So long as they
existing
are-
living area.
As long as they are already
Yeah,
habitable
as long as they are
space.
existing living area. If it's not built out, it's not
Right,
existing
I
living
agree.
area.
I just want to make sure we're, that.
What we would suggest
Included or.
to accomplish that goal is two things. One would be in the definition of living area, on the definition section, add in legally permitted, to make it very clear. If you just finish out your attic without permits, it doesn't count. And two, on the table to put the footnote that ties it straight back to that definition.
Okay,
So,
perfect.
I mean, it's accomplished through the definition tie, but we'll make it very, very clear. So add a footnote to the
Thank
definition.
you. Would you recommend can we just take a poll without having to make a motion and make a vote? Just take a poll of,
Yeah, you could take a poll and then do a formal
would that
motion
be
later.
okay, Chair?
And
The chair would
before
have
you
to set that up.
Right, no.
take the poll, one quick other change while we're on the point. Looking again at our habitable definition, I think we should change it as well to be habitable area rather than habitable space, consistent with the rest of the uses of area, not space.
It's in definition
That's number 9 of the definitions.
Thank you.
habitable area, okay.
All right.
And we'll
So
run a search
what
on the
I'm
rest of
going
that
to propose
term.
is that we just kind of go around the table, almost like at a concept review, and each person can state their opinion about the 50% versus minimum. What are we actually discussing here? What is your question?
Well, I think
Minimum lot.
my desire would be to try to get, for the purposes of the ensuing staff report, which will advise city council, to sort of put a little more character on how strongly we feel, or not, about the limiting the maximum floor area of the unit by 50% of the existing habitable space. To put a beat on that, rather than Mr. Quillisi suggesting that we note division, but I think we're more divided on minimum lot size than we are on this issue, and I just wanted
Correct.
to.
And I'd be happy
dress
to
that up.
stipulate 6-1 on 50%.
Right, and I just want to, I think that's what it is.
All
I
right.
think that's
No?
what it is, but I think we should poll, just.
All right. Does anyone else have a strong opinion on 50% versus,
I'm in favor of 50%.
all right? Bobby? Yeah? Mr. Quillisi?
And I disagree, so it's
Disagree?
6-1.
All right. Kathleen?
I agree on 50%.
All right. Okay, there's your answer.
And you?
All right, you're welcome.
Do you, no, do you agree?
You do have to vote.
I know, I guess I did. Well, I don't know. I'm the chair, I can.
You don't have
Oh,
to.
you can abstain.
Yeah, it's not a.
Yeah, it's, I think the 50% rule makes sense to me, as long as it's clear that it's habitable space, not just any old space that you happen to have in your house.
Thank you, Chair.
Makes sense to me. All right, there you go.
That's what I stipulated.
So, do we have further discussion, or would someone like to propose a motion, and we could move this on to the city council?
We were going to get a sense of the commission, I think, on minimum lot size.
I'm not sure I want to get into that, but
Okay.
we could certainly do that
I think
in the
it's-
same kind of format.
It may be sufficient that the city council knows there is an ongoing discussion here.
All right, well,
About-
let's go the other way then. So Ray, do you have an opinion about lot size versus, a specific size, a specific?
Yes or no, should there be a minimum lot size?
I'd like to see a minimum lot size.
Okay, Kathleen?
with
No
the-
minimum lot size.
Okay, I'm not concerned about the minimum lot size.
I agree, no minimum lot size.
No minimum lot size.
No minimum lot size.
Keep the minimum lot size.
All right, so there you go. That's a,
Very good.
that's a 5-2 vote. Would someone like to make a motion on this? As I was going back and looking at this, I
I will.
realized.
I'd like to make a motion that we adopt, that we, I don't know, what are we calling this? Our,
That we,
Let's say in
we're-
the-
we recommend
We
to the city
recommend
council.
that,
We passed the resolution.
Yeah, you're adopting a resolution that's
Oh, yeah.
recommending
Resolution.
adoption by the city council of an ordinance amending section 10-1709 governing second residential units and accessory dwelling units to conform to new state statutory mandated second unit ordinance requirements and to further modify accessory dwelling unit standards and a finding that the adoption of the ordinance is exempt from CEQA.
Okay.
how would we sort of,
Amended.
as amended?
And then as amended,
As written by staff?
Recommended by.
As recommended by
and we
staff?
could review the amendments were we aware from tonight's discussion, if you'd like.
There was a lot of it.
Go through those
Yeah.
real quickly.
All right,
Staff can just
let's see what we're talking about.
Okay, so the ones that I have are as follows. And this is starting on, again, the red line version, which is what I've been marking up. Page 3, definition of accessory dwelling unit, add in, an ADU must have either independent exterior access or independent interior access. And that concept might show up at another point, so we would make the change as needed elsewhere. On the next page, define it as habitable area, an area within a building designed for general living, sleeping, eating, or cooking purposes, deleting the sentence that reads, it's not necessary that a room or area be finished in order to be considered habitable space. Under home split, keep the definition the same, but change out the phrase living space to be living area. On living area, keep the existing text, but define it as living area means the interior legally permitted, added 2 words, habitable area with minimum dimensions of 8 feet by 10 feet and with at least 7.5 feet of headroom of a dwelling unit, including basements and attics, but does not include a garage or any accessory structure, add the period. On the next page, as in the red line, on the next page, on the minimum lot size, point to the council that it was a 5-2 split decision and describe the debate and the points raised on both sides in the debate about minimum lot size. On the next page, maximum floor area, the same. Point out that it was a 6-1 vote, and then articulate the arguments that have been raised on both sides of having the 50% requirement or not having it, and add in for all across the row a footnote to the definition of living area. On the next page, on actually 2 pages, on page 10 of 14 for non-habitable accessory structures, add that it be permitted in compliance with applicable city regulations across the board, and expand the definition to be in the first box, habitable structures to include, expand it to be habitable structures with a half bath, up to a half bath. May include. Yeah, let's do that as may include. Thank you, Mr. Winiger.
Where does that go?
We'll add a footnote,
Non-habitable accessory structure.
just say that non-habitable accessory structure may include.
What
Okay.
page are we on there?
Okay, it's on page 10, top row.
All
So
right.
there's going to be another footnote.
Yeah, we'll put a footnote that builds into the concept. Maybe we'll define it as just accessory structures, and then we'll say, footnote defining that to be non-habitable or habitable with up to a half bath, without a full bath and with no kitchen. Building in the concept of,
Offices, workshops, art studios.
right, may include a half, just making a quick note here, may include a half bath or be non-habitable. Okay, and then on the next page, page 11, section 1F, keep the beginning of the first sentence, both primary and accessory dwelling units shall be connected to the public sewer system, period. And then keep the language at the bottom, notwithstanding the foregoing, you can connect to septic. And then add in a language to the effect of common metering or separate metering to be the applicant's option. That would allow, as we had discussed there, the applicant's choice. And in all cases on that, you have to meet the building official's approval in terms of you have to show effectively working utilities. But bearing in mind the council's action the other day, the proof of effective working utilities need not require a will serve letter, does not require a will serve letter from the utility. It can be proved through alternative methods, which would be a physical connection and a utility bill. And that's already adopted by the council's policy. Next page, on 12, fees at the top, no connection fees, capacity charges, school district fees, or similar impact fees shall be assessed on an accessory dwelling unit by the city, period. And then keep the added sentence that application fees still apply. And that's it. That's the changes that I have recorded.
Okay. Bobby?
Can I just clarify on that first one? It can have either an exterior access or an individual interior access or both?
Oh, yes, we could do that. Must have independent exterior access and or independent interior access.
Right.
Thank you. Mr.
Yeah.
Summers, thank you for,
Excellent.
yeah, condensing all of this.
Happy to
into
provide the service, thank you.
Something that's just comprehensible. I'm very impressed. So, Commissioner Zabella, are you happy with that as your motion?
Yes, I couldn't have done it
All
better
right.
myself.
Thank you.
I'll second it.
Thank you, Chester. All right, we have a motion and a second. Is there any further debate? Good. Could we have a roll call, please?
Isabella?
Yes.
Corbin?
Yes.
Jagiella?
Yes.
Quillisi?
Yes.
Merck?
Yes.
Nolan?
Yes.
Powers?
Yes.
Thank you all.
Passes.
Hopefully, we won't have to do another 8 meetings on the next
Yeah.
one. Yeah, yes.
That,
until we get
ladies
to
and
the-
gentlemen, is sausage being made.
There you go. This is what democracy looks like. We are on to our discussion items. The first is future agenda items.
Item 6, yeah.
Yes, Mr. Chairman, we show a couple items on your June 7th agenda, including the Complete Streets Master Plan discussion. That is subject to additional evaluation. We're in discussions with Public Works staff regarding that. And then we have one item, and that is also tentative as well, but we are certainly endeavoring to meet the June 21st agenda for that.
Okay, thank you very much. And then we're on to Planning Commission committee reports. I am in the midst of watching the video of the City Council meeting on May 9th. I attended for a while, and then I've gone back to the video. So I'm not ready to report on the meeting yet, because I haven't watched the entire thing. Do we have a Complete Streets?
Actually, I believe, Steve, you gave a wonderful report on Complete Streets. At least I listened to the recording, and you did. This was from our meeting on
Okay.
the beginning of May, so I think we're fine. Chair, I know that it says no report for the Sustainability Committee, but I wanted to actually bring something to the commission and make a request. And that is, it's something that I brought to the commission last year in regards to the potential of the city council looking at a sustainable research ordinance. And what it does is it potentially could affect planning and it could affect building, which would bring in the Buildings Appeals Board. But it's the opportunity to allow permitting for something that's not in the code presently. You have to come in and you'd have to have all your information. They're looking at this in the city of Santa Barbara, the county of Santa Barbara, and the city of Goleta. And what they're doing is they're aligning with a university. It could be like Cal Poly, UCSB, and what have you. So basically, you're coming and you're proposing to do something that's not in the code. I'm just going to say this, for example, I'm not saying we have to do this. It could be like a composting toilet. It could be something with planning where we allow something that's not there. You have all your data, you come in and you apply, but you collect data, and while you're testing to see how these things work, it allows you to write it. In other words, if something goes off schedule or is a little bit different, you have the opportunity to fix it and make it work. That information could then go back to the city, and I would say we may want to look at it as on a pilot project basis where we say, I'm just using this for example, once again, maybe the city says, well, we'll allow 2 of those a year. I'm just proposing, making this up at the moment. But when the information comes back and then somebody else tries it, it could be the basis of allowing something new in the code. So for instance, like if I want to build a straw bale house, I do it, it's illegal, I get busted. 20 years later, finally, the county or the state says, oh yes, we'll legalize it. So rather than making it illegal and also stopping the potential for something good to come to the code, it allows an experiment, so to speak, or a pilot project to happen. And data's collected. It has to, for instance, if it was the composting toilet, everything would have to be done correctly and documented and what have you. And where I'm going with this is I would like, if Planning Commission was in agreement, the man from Santa Barbara who initiated this, and I've been in contact with him for about the last year and a half, would be able to do a presentation at City Council, and of course we'd have to find out if this was, there was interest and the availability, to do a presentation on June 27th. I did briefly mention this at one of our joint meetings with City Council this last year. I only had a minute to say something, so I really didn't get to go any further with it. So my request is there interest from the Planning Commission for this to be presented to City Council? And if so, I would be asking staff if there's a possibility of us getting on the agenda for June 27th.
I'm wondering if there's like really broad interest in something like that, and if it might be better at like the Chaparral Auditorium or something where like many people could attend it rather than a city council meeting.
Right. My intention was first to take it to City Council to see if they were interested, and then we could do potentially, a more public, that will be public, it'll be at City Council, but at a larger venue.
Yeah. I don't know, it's worth thinking about. Anyway, can we bring that up with City Council?
Certainly, we'll bring it up to City Manager. I do know that the council agenda in June is very heavy because of the budget. So there may be some challenges with that particular date, but we'll pursue it with the City Manager.
Okay.
And the mayor as well, is the mayor and the city, the mayor controls the agenda with the consultation of the city manager and the rest of council. So we'll pass along the request and we'll let you, we'll connect you with Mr. Johnston and Mr. McClary.
If there's, I was going to say, ask if there's any information you can provide in advance that we could share to further
I'll do that.
provide some detail, that would be helpful.
Excuse me, I will email you over some information.
Great.
And
Thank you.
What I was going to suggest, why don't we have them present to the Planning Commission? And then it would be recorded, then they can watch it, and we would have a chance to understand it
That's what,
too,
June?
and whether or not we're.
because there is a
7th?
planning component.
Yeah,
and
like
there's
we
a
did with
building
tiny
component.
homes, we looked at that first
Right.
before we sent it to the
June 6th,
building
I
council.
think.
What do we think is a better approach? Would it?
I would say, because
Planning
of the
first?
schedule, I would rather see it come here first, so I can get a better understanding of
Mhm.
what we'd be,
Be okay.
having
I'm
city
okay.
council look
Yeah,
at.
we have room on our
Yeah.
future
Would
agenda
that be
items,
okay
so
then to do it?
That's worth
All
looking
right,
into.
and then, if there's further interest and we needed to go to City Council for a presentation, then we could do that.
They'll have at least a video to watch and.
Exactly.
To,
Okay, good.
Yeah.
And I will still send you the information. Okay, good.
Yeah, we could just call it Concepts for Sustainability Pilot Programs,
Perfect.
something like that.
Something like
Yeah,
that.
that's a good title.
I'd be interested in seeing it, as long as we all understand that there are still overriding public health, public safety.
Right.
And
And I-
under the BAB building standards codes.
Exactly.
That would all require waivers of some sort.
Yeah, and I did mention that earlier, that, what they're proposing right now, there's, or I'll call it a tract, if you will, and you could pick one or the other or both, but there is one that does affect building code, and the other one planning. So we can have him give the entire presentation. BAB members
Yeah,
could
we can
look at it
invite BAB
too.
members to come.
Exactly, anyone
Yeah.
could come to that meeting, so.
And if they don't, it might be advisable to ask the BAB if they would schedule the same presentation,
Right,
because it does overlap into their jurisdiction.
Yep. Commissioner
potentially
Powers.
could.
Thank you, Kathleen, for bringing that up. Just in addition to that, because at the last council meeting, I did get up and share about the need for some alternative building materials and approaches if we're really going to support lower income and affordable housing, because it's just costs less to build cob and straw bale and those type of buildings. And I'm aware what they're doing in Goleta and Santa Barbara, and have been researching that myself and know some of the people involved. And Mayor Johnston, at the end of the last council meeting, did talk about a public workshop where someone would come in and talk about zoning and the different approaches. So if we did have someone come to the Planning Commission first, because we can kind of fast track that, that could be an introduction
Yeah.
to us.
We can look at the land
on
use
the
and zoning
commission
aspects of that.
prior to a
of that,
public workshop,
topic,
if
and then
that would be the
BAB
next
can
step.
handle the building standards portion.
Thank you. Thank you. Thank you. Mr. Haney, we've come to your portion of the program.
Is he still awake out?
Oh, yeah. Yes.
Wide awake. So, good evening. Great job again. Ceases to amaze me. I just sit back here and just watch you guys go at it. Great discussion tonight. A lot of great discussion, a lot of good points. So I'm not going to comment on any of them because they're all coming to us. I do want to do something, though. I'm glad that, Chester, you brought up the fact of bringing this Santa Barbara thing that Kathleen discussed, bringing it to you first. I think it's a better idea for it to be here. I think it's a better idea for the public to be here to see it and to comment and to understand it better. And I do share Mr. Quillisi's concerns about BAB, seeing as how your purview is not toilets.
And I
Maybe
did
in
say
the
that.
space of where the toilet goes, but not in the toilet. So I think that you have to be aware of that of our past interactions with stepping on each other's toes. So it just would be leery of that, but I think it's a great idea, and I'm behind it 100%. What I'd still like to hear is, I know you and Chester are on a sustainability committee. Like to see that, looked at, and you guys start bringing ideas regarding that. We did have a discussion at that Design 2 about sustainability, and I think I talked about it at the last planning session committee or meeting, and that was how we look at sustainability and to how we live in Ojai and how we apply it to everything that we do. So again, that's something that you two have chaired or are looking into. You don't have to wait for us. That's something you might look at. When I ran for council, one of the questions was, what are you going to do about affordable housing? So 2.5 years later, that question is still in the back of my head, because my response was, affordable and affordability has a different meaning to every one of us in this room. It just does. So when someone says, what is your guys on affordability, or what's your take on it? It's like, well, listen, I'd like to live in Malibu, but I don't know if they're going to build me a home there that I can afford. Now, I heard that from a friend of mine. I thought that was a pretty funny comment too. But I think personally, we all look at affordability, and I think Mr. Ehrlich was talking about it. The state mandate regarding what's taking place right now on these accessory units is the fact that there's a lot of communities that want zero growth. And there's a lot of communities that want slow growth, no growth, or just don't even bring that word up. And so affordability comes into that conversation. If you don't want to grow,
How can you grow to some form of affordability? So you can see there's a big, there's a big broad discussion that has to take place there regarding what is affordable. When I hear affordable today, the back of my mind says rent control. Now, I'm gonna tell you what, you bring rent control up to the public, and I'll tell you what, they all say the same thing. Steve, we don't want that. But if you want to create affordability, you better think about how you're gonna manage what someone can charge for a dwelling. And right now, in the American dream, this is only my opinion, probably shouldn't say it, but in the American dream is, you don't have the right to tell me what I get to do with my property, and what I charge for my property, and what I can make on my property, do on my property. That's a big argument between them, and it goes a lot of different ways. So, again, I'd like to see the word affordability, and I'd like to see it in a discussion with the community, so that we maybe remove everyone's different opinion and kind of coalesce about what that word means to our community. I think that's a broader and a better discussion that we could have. And once we do that, then we can start looking at how we do that through our building codes and through our planning and things of that nature. So affordable and affordability, it's a tough
Squishy,
conversation.
yeah.
So, but it's a good place to start, and this room's a great place to start it if you guys choose to champion that too. That's all I have, other than you guys did a great job tonight, a really good job. I'm happy to see it, and I'll be interested to see the complete package. Matthew, great interpretations. Matthew, thank you for doing a great job too.
Okay. Any questions for Mr. Haney? Yeah.
Well, not so much a question, but possibly a comment. Just to point out in my language, that's why I say affordable housing / lower income. So someone making $15 an hour, bringing home $2,000 a month, isn't going to be able to spend $1,800 to rent a converted garage ADU. It's not possible.
Well, and that
So-
goes back to, again, what I just said is, if I just invested $40,000 into a room or an ADU, are you telling me that I should set the price of renting that room not to recover my costs? Or do I set the price of renting that room to someone that can only afford $500 a month? That's the issue.
I get it.
And it's a tough one. So, and watch, I'm a proponent. We're a service industry in this community. And I know a lot of people that are making that $15 an hour or $12 an hour or $10 cash. I know that. I know a lot of those people. You know, all of us at one time in our lives were making peanuts. You know, I was making, I'll never forget this. I was making, I'll never forget this. I was making $1.25 working for a plumber when I was 18 years old. And the journeyman I was working with, he was making $8. So him and I were constantly talking about, God, how can I make more money? So he goes, well, go ask Spike for a raise. You earned it. You're worth it. So I asked Spike for a raise. You know, I think I'm worth, 25 cents more. And he said, well, you know what? I can find tons of you guys. And I got fired. So it's just, we all got to go through these rites of passage. We all got to go through these things in life where, guess what? It's not fair. And what that does is it makes you strap on the bootstraps. It makes you, buckle up. It makes you toughen up. It makes you a better person. And as parents, we do that all the time with our children. But more importantly is that's just part of all of this too.
I just see it's so important to, and I get this isn't a dialogue we can go on too long for, but I just think it's so important to include the service industry and the labor people who are forced to commute into Ojai. So, for instance, I personally don't think a lot of the traffic has to do with tourists. I think a lot of it has to do with people that work here that are not able to live here and are having to commute back and forth from another area.
I don't disagree.
So if deed restrictions were legal, and I get they're probably not, there'd be a way to restrict, like here's how much, and I'm not for rent control, but there's somewhere in something that hasn't been created, it's What's invented, been invented, but there's possibilities we probably haven't spoken about yet
Right, this is
that
a-
were within the purview of the law.
Like I said, this is probably not the place to have this discussion, and so I'll end my part of it. But I'll end it with again, you guys are doing a great job. You are completely appreciated by the community as well as the council. I know that for a fact. So thank you.
Thank you very much. That concludes our meeting.